Hello and welcome back. We're doing really well. We're working through company law. It is quite a long chapter, this one. You just have to stick with it. We're moving on now to look at shareholders and shareholders' rights. So this is quite an important section. Now, the shareholder, as you know, is the person who owns the shares in the company. And ultimately, it's them who will have the benefit if the company does well or not. Now, shareholders' rights are generally contained in the Articles of Association. You'll remember we said earlier that these act as if they are a binding contract between all of the shareholders and the company. Now, we might also have something called a shareholders' agreement. This is like a separate document that sets out the terms on which the shareholders have agreed to interact with each other. There may be controls in there about what happens if a shareholder wishes to sell their shares, what happens if they want to buy more shares, things like that. Now, a shareholders' agreement has an advantage over these provisions being contained in the Articles of Association, and that is that the shareholders' agreement, unlike the Articles, is not filed with the company registrar. It is not a public document. So sometimes if there are private details which govern the way the shareholders conduct their business, it's better to put it in a separate shareholders' agreement. Now, looking at the shareholders' rights, there are a lot of rights. There's a list there for you. These first 1, 2, 3, 4 of them, these are all personal rights that accrue to the shareholders. In fact, we could also count the next 2 as personal rights of the shareholders. So that is important. These are things that he can do in his own right just because of the fact that he owns shares in this company. So what have we got? To send a copy of the annual accounts and reports, to demand a general meeting held, and also to schedule an item on that meeting. To appoint a proxy, that's someone who attends the meeting in his place, has the rights to vote, to speak at the meeting, and so on. The right to remove a director if he can rustle up more than 50% of the votes. Also, statute gives him certain rights to approve actions of the directors. And there are some specific minority rights, again, that accrue to individual shareholders, triggered by the percentage shareholding that they have. And we're going to look at these 2 categories in a little bit more detail. The following 3, these are slightly more complicated rights. And they'll each require a little bit of thought and explanation as we go through the notes. So we'll work through that as we go. So first of all, approval of directors' actions. What do the shareholders actually have to approve? Well, directors' service contracts if they are more than 2 years. Now, the reason for that is shareholders have the right to remove a director. But if that director has a 2-year service contract, although it doesn't stop the shareholders removing the director, it's going to be pretty expensive to pay him off. And therefore, we have to make sure that the shareholders were happy with that service contract from the start. Also, we have provisions regarding substantial property transactions. And this is where the director acquires an asset from the company. And again, it's to stop him buying an asset at a discount and basically secreting funds out of the company without the shareholders knowing about it. So to be substantial, first of all, it needs to pass one of these tests. It needs to be more than 10% of the company's net asset value and greater than £5,000 or over £100,000. And if it does meet those tests and it's a substantial transaction, then without shareholder approval, that transaction will be voidable by the company because the company would be deemed to be the injured party here. Now, also, the director can be liable to account for any profit that he's made there. Now, this sort of transaction doesn't come up that often. When it does, it's quite often to do with the director buying his old company car from the business, and it's to make sure that he's paying a fair price for that asset. Another provision would be where a company makes a loan to a director, either directly or by guaranteeing the loan that's given by another party. Again, if we don't have shareholder approval, that transaction would be voidable by the company. And also, the director could be liable to account for any profits he's made. Payments for loss of office. Now, we're not talking about contractual payments here that are already approved under the terms of the service contract. We're talking about something else, a sort of ex gratia payment, a discretionary payment. And in this case, we need to make get the approval of our shareholders. There is a de minimis exception, but you can see there it's £200, it's tiny, so it's not very likely to apply. Again, if you don't get shareholder approval, what are the consequences? Well, the payment is held on trust for the company, and any director who authorised the payment, not necessarily the one who received it, is liable to indemnify the company for any loss. Okay, so those are some sort of simple provisions there. What if you are a minority shareholding in the company? Well, the basic position is that the company is controlled by the majority shareholders. It's the majority decision of the shareholders which will prevail. It's the majority of the shareholders that have that power to control the company directors. Now, unlike company directors who are governed by the duties we saw in an earlier lecture, shareholders don't have to do that. Shareholders can act in completely their own interests. Now, the basic rule is sometimes called the rule in Foss and Harbottle, and in this rule, a minority shareholder tried to bring an action to sue the directors of the company for defrauding the company. But the court said the action had to be dismissed, and the reason for that is that the company was the only person who could bring the action, because it was the company that had been wronged. Therefore, an individual shareholder couldn't bring the action. Now, you can imagine this could cause a problem, because who is the person who is in control of whether a company brings an action? It's probably the directors, or at the very least the majority shareholders. And quite often they are one and the same person, and quite often it's one of those groups of people who are actually in the wrong. So how is the minority shareholder to be protected? Well, we need to look at a number of specific provisions here. First of all, statute gives a certain number of powers that allow a minority shareholder to bring an action in his own right. And there's a little table here that tells you the details there. We can go through it very quickly, but these are all provisions that we'll pick up later on in the notes. A variation of class rights, 15% can object. More than 5% of the shareholders can call a general meeting and can also schedule an item on the agenda of that meeting. Any shareholder can object to a payment out of capital to redeem shares, and any member can object to a company being re-registered as unlimited. In addition to that, we have this thing called derivative actions, because in some circumstances, the only way to take action against the wrongdoer is for an individual shareholder to initiate proceedings. And what happens in this case is that the individual shareholder starts the proceedings on behalf of the company. So either perhaps a breach of duty by a director, or maybe some act of negligence. And the court will review the case and will decide whether to allow it to continue in the name of the company, i.e. as a derivative action, or to strike the case out. Now, the court's looking really to see whether this particular shareholder is really a troublemaker, or whether he's actually got a bona fide claim. So he's looking at, is that shareholder acting in good faith? What sort of importance do the other shareholders attach to this matter? Is it likely that the rest of the company would ratify this action, so there's just this one shareholder acting on his own? Has the company already considered this problem and decided not to pursue the claim? I.e., again, is this one shareholder maybe pursuing a vendetta? Now, the courts will also look, if it's a negligence proceeding or a breach of trust case, at whether, if it's a director who's been sued, whether he acted reasonably and honestly. Because if he did, the courts might excuse him anyway for his behaviour. And that's something that happened in this case of Rue de Jeanne. In this case, the defendant was a director of a company, and he signed an insurance proposal form without reading it. I know, we've all done it. The form had been filled out by his broker, and he thought it was okay. As it always happens in these cases, there was a fire, and the company lost out because it couldn't claim under its insurance contract. And basically, it was the fault of the defendant to the director. He hadn't checked the form, therefore he was negligent. Now, the court said, yeah, he was negligent after all, but he wasn't dishonest. He'd acted reasonably and honestly. He'd also lost most of the losses accrued to him personally, as he owned 99% of the company. Therefore, it was relevant that he'd already suffered such a huge loss. It would have been more unreasonable if he'd been playing with someone else's money. So in this case, the director was held not to be liable. Another grounds for action by a minority shareholder may be to bring an action on the grounds that there has been unfairly prejudicial conduct. Now, what we're really looking for here is that the majority shareholders are acting in such a way as to exercise their powers in a way which is to the detriment of the minority shareholders. And there's been a number of cases on this. Again, how could the examiner test you on this? He's quite likely to just test you on the cases that we're going to discuss to see if you've understood them. So, in one case, for instance, a minority shareholder had 26% of the shares, and she actually suspected the managing director of the company of paying bribes. She tried to get an investigation trigger an investigation and failed, and then shortly after that she was removed from the board. Now, she said that's unfairly prejudicial conduct. I've always been involved in the running of the company. It's a quasi-partnership in the same way that the Ebrahimi case that we saw in an earlier lecture was a quasi-partnership. And the court said that in this situation where a person had an expectation of running the company, it would be unfairly prejudicial to remove them from the board. We've got some other examples here. Improper allotment of shares. In one case where, I think it was a niece and an auntie in this case, and the niece kept blocking the auntie's resolutions to make changes to the company. So the auntie in the end had a majority shareholding, issued shares to friendly parties, and then she could outvote the niece on every occasion. That was also unfairly prejudicial conduct. Making inaccurate statements to shareholders. In this case, the shareholders were persuaded to accept a takeover bid, which was actually not in their interests because they'd been presented with incorrect information. Another case is where the owners of a business actually diverted contracts to another company which they owned. So they left the shareholders owning effectively an empty shell company with all the useful, lucrative business being transferred to their own company. It's as important to know what is not unfairly prejudicial conduct as it is to know what is unfairly prejudicial. Failure by a parent company to pay the debts of a subsidiary. Well, we've already seen they're separate legal entities. A parent company has no liability for its subsidiaries' debts. Non-compliance with stock exchange rules, again, is not unfairly prejudicial conduct. It's worth noting this point here is quite important. Where a company has made, or where the majority shareholders have made a reasonable offer to buy out the shares of the shareholder who's bringing the claim, the court are likely to expect that shareholder to accept the offer. But the key term there, it must be a reasonable offer. Also, the basis of the claim has to be made as a shareholder. Remember, we're talking about shareholder rights here, not as an employee, not as a creditor. And the example there is this case O'Neill versus Phillips. So in this case, Phillips owned 75% of the company, but he let O'Neill manage it. And as O'Neill was managing the company, it was decided that he could take 50% of the profits. They did talk about increasing his shareholding in the company, but they never actually did it. So for a while, O'Neill shared equally in the profits. After a while, the business didn't do very well, and the owner, P, decided that he would take control back. So he just demoted O'Neill and withdrew his profit share. O'Neill wasn't very happy. He said he had an expectation here of being made an equal shareholder. And therefore, he tried to argue unfairly prejudicial conduct by Phillips. However, the court said there was no agreement here. Therefore, there could be no shareholder right that Phillips could enforce, and it was perfectly reasonable that Phillips took the company back. There was a statement, this is the word obiter, that means sort of by the way, it's not a legally binding statement, but there was a statement that was made that suggested that perhaps if we had had some sort of legally binding agreement to transfer shares to Phillips, that might have been enough to give him the basis of a claim. But in this case, it wasn't. Now, it's not enough just because you don't like what the managers are doing. It needs to be something that actually causes prejudice to the shareholders. And that was the argument in Ria Company. Also, again, quite an important point, the courts will take the petitioner's conduct into account. So if the shareholder has done something wrong, then that's going to influence the outcome of the case. Now, in this case, it was one other of those cases where we had a group of directors, one of whom wasn't really involved in the running of the business. He'd left it that if anything happened that was important, he would be consulted. Never really made any effort to find out what was going on. And then, when things started to go wrong, he tried to claim that it was unfairly prejudicial conduct, that he'd been excluded from the management of the business. The court studied this scenario and they said, well, we're not really convinced because really you've excluded yourself from the management of the company. It's not an example of unfairly prejudicial conduct. So his claim failed. If your claim is successful, however, what might happen? Well, first of all, the court might make an order regulating the company's future affairs. So, for instance, it might dictate how meetings should be conducted. It might authorise an individual shareholder, a minority shareholder, to bring a derivative action proceedings on behalf of the company. It might give an injunction to stop the company continuing with a certain act, or it might require the company to change its articles of association. And finally, and probably most likely, it might make an order that the majority shareholders buy out the interest of the minority shareholders at a fair price. Now, that fair price is the price before the prejudicial conduct happened. The value of the shares before they started to decline, as prejudicial conduct will inevitably reduce the price of the shares. It is also the price which would be paid ignoring the fact that they're buying a minority shareholding. Because what should happen in a commercial world is that if you are selling a tiny minority shareholding which doesn't give control of the company, the price per share will be less than if you were selling a shareholding which formed part of a majority holding. So in this case, there is no discount for that minority holding. Now, I mentioned that the examiner is likely to test you on the outcome of those cases, and that's exactly what this question does. So have a go at it, see how you do. So the answers here: failure to pay of a parent company to pay the debts of its subsidiary is not a ground for unfairly prejudicial conduct. Diversion of business clearly is. Failure to call a meeting, perhaps surprisingly, has been held to be unfairly prejudicial, and late presentation of the company's accounts isn't. Okay, one more proceeding which could be brought by a shareholder. And this is a proceeding for just an equitable winding up. Now, we've already seen this in the case of Ebrahimi v Westbourne Galleries when we were looking at grounds for lifting the corporate veil. Do you remember he gave some of his shares away to his business partner's son and was then removed as a director? He petitioned for just an equitable winding up as a result. Basically, just an equitable winding up is available to any shareholder who's unhappy with the way the company has been run, but he must show that it's just an equitable to wind the company up. And the courts have said that this is a step of last resort. There must be no other way out. And they have been quite strict about that in the past. For instance, in Ria Company, the parties argued that the working relationship had broken down and they wanted to wind the company up. However, there was evidence that the parties had agreed at one point that one would buy the other party out. and the problem was they couldn't agree on a price. So this was the minority shareholder who was bringing the action. The majority shareholder wished to continue with the company, preferably without the minority shareholder to get in his way. The court refused to give an order for liquidation because they said there is another remedy. You've shown that you could reach an agreement, you just have to sort out the price. So even though price was probably the biggest stumbling block and the hardest to resolve, the court didn't wind the company up, it sent them away to resolve the problem. Now, where have there been successful claims? Where a company was formed for an illegal purpose? Where there is complete deadlock in the management's affairs. And this is what happened in the Uniji Tobacco Company case. In this case, two sole traders merged their businesses and then they fell out. One of them accused the other one of fraud. And as a result, they could barely even speak to each other. They used to pass notes between their secretary rather than actually exchange words with each other. And in this situation, the court agreed that in this company, there was no way it could continue on. The parties couldn't work together. Therefore, it was just unequitable to wind them up. Okay, now that brings us to an end of this lecture on shareholders' rights. Now, to complete this company law chapter, we've got to look at meetings, and we'll do that in a separate lecture. So I'll see you then.